Recording. And I'm going to start to admit everyone.
Okay.
Hello, all. Just going to let the waiting room filter on in. Just letting that waiting room filter in, making sure all the attendees can come before we get started. Thank you so much for joining us this evening. I hope everyone had a lovely Thursday. We've almost made it to the weekend. As I like to call it, it's Friday Eve. So we're just going to give it another minute or so just to make sure anyone else that wants to join can make it from the waiting room. There we are. Here's some more waiting rooms trying to funnel in. And just as a friendly reminder, we are recording tonight's session. Feel free to use the meeting chat for any questions. I will be monitoring that and trying to give Henry here a heads up for any kind of either thought starters or questions or any kind of commentary. So in between some slides, we can kind of do a check between us and, and check the chat every once in a while, because I'm sure there will be some great commentary there.
I do I do leave time for questions at the end as well.
Oh,
So I will if there's something pertaining to the slide, you're welcome to ask. But there will be time at the end for questions.
wonderful. Awesome. All righty. And with that, again, just one more note of gratitude and thanks for everyone coming tonight. This is going to be an exciting presentation, not only because it's led by our very own Henry Mantel, but because I think just in our current time, especially as PLB residents, knowing our rights is just so important. And so a little bit about Henry, just to kind of set who he is and why we're all here. Henry here has been a resident at Park La Brea for about 5 years and has been a PLBRA board member for the past two. So he's been heavily involved in this community, has seen a majority of the issues that have been surfaced amongst the residents. And he, in his day job, is a tenants' rights attorney, and he's represented tenants in eviction and slum housing cases. So he is going to be the perfect expert tonight to talk about, again, what rights do we have as renters? That is just my quick bio. But Henry, let me pass that torch over to you so you can share a little bit more.
Thank you, Ashley, and thank you, Ashley, for putting this all together. It is great, and I appreciate it. Hello, everyone. My name is Henry Mantel. I am, as Ashley said, a Park La Brea resident like yourselves, and also a tenants' rights attorney. I have done eviction defense work and slum housing work, and yeah, and I want to tell you all about your rights. And as I mentioned, there will be some time for questions at the end, but feel free to put questions in the chat. So we're just going to get started. So this is kind of just what I'm going to talk about in general. I want to start by talking about the Park La Brea Residents Association because I think it's a great group of tenant advocates. And then I want to cover the Los Angeles Rent Stabilization Ordinance, the implied warranty of habitability, a landlord's right of entry. I'm going to go briefly into discrimination and reasonable accommodations. I'm going to talk about evictions and government agencies, and then give you a little bit more about further resources, and then we'll have time for questions. And I just want to make clear right off the bat that this is very truncated presentation. I could probably give a 45-minute presentation on each one of these things. But I'm going to try to give you as much information as I can in the time I have. Okay. So just first, a little bit about the Residents Association. I would encourage you to join. If you want to join, there's a QR code to our website there you can scan. Because Park La Brea is pretty big. We are the largest housing development west of the Mississippi, which is kind of mind-blowing. This whole development was built in the 1940s, and we have more than 4,200 units, more than 14,000 residents. So this is a really big development. There are a lot of us here. And we are stronger when we work together. And this is something I actually tell tenants all the time. It is always better to talk to your neighbors about issues before going to management or making sure you have your neighbors on your side if you do or if you ever are going to complain. And PLBRA, we're a registered 501(c)(4) nonprofit organization. So we do lobby or we do advocate for changes to public policy as well as advocate for you with management. And most importantly, we are not associated with management. We are fighting for you. Management d oh, does not like us. So we want to fight for you as much as we can. And if you want to become a member, it's $20 per year or $30 for the family membership. So highly encourage you to join. Okay. And just a quick disclaimer here, nothing in this presentation is intended to be legal advice. This is for educational purposes only. And something to bear in mind, the information presented in this presentation is subject to change. And that's actually kind of important because since the last time I did this presentation, there has been a pretty significant change in the law. So just be aware that if you're watching this at some future date and the recording, things may have changed, but I will give everybody information as best I can now. And I'm not agreeing to represent anybody or take anyone on as a client. And nothing said or asked here is confidential or protected by attorney-client privilege. So just bear that in mind. Okay. So we're going to start by talking about the Los Angeles Rent Stabilization Ordinance, or LARSO. LARSO is LA's rent control and just cause protections. It applies to most multifamily housing built before 1978. And if you want to look it up in the LA Municipal Code, you can just Google LAMC Section 151. That is where it's found in the city's municipal code. And Park La Brea, because we're a multifamily development built before 1978, is covered by LARSO. So if you're ever curious about what your rights are, you really just need to consult with LARSO. And LARSO includes two major components, the first being rent control and the second being the just cause protections. And LARSO units are regulated by the Los Angeles Housing Department. So they are the government agency that you would complain to if you have problems. And I will go a little bit more into that later in the presentation. So rent control. And when I mentioned that there have been changes to tenants' rights in the last year, this is mostly what I was talking about. Because in the last year, just recently, the LA City Council tightened up LARSO a bit, so they actually reduced the amount that landlords could raise the rent by. So now, as of this month, landlords can only raise the rent once a year, and they can only raise it 1 to 4%, which is determined by, which is 90% of the change in the consumer price index. And so starting February 2nd, 2026, it's limited across the board to 3%. Now, when a landlord wants to raise your rent, they have to give you at least 30 days written notice of the increase. And if they don't do that, it could potentially be considered an illegal increase. Now, landlords can reset the rent if a tenant vacates. So, if a landlord, I've unfortunately seen situations where long-term tenants who have lower than market rate rent because of rent control are dealing with evictions because the landlord just wants them out so that they can reset the rent. It unfortunately happens, but legally, landlords are allowed to reset it if the tenant vacates. And landlords can also pass through the SCEP fees. SCEP is a program that requires landlord basically requires investigations into units every few years to make sure that they are habitable, make sure they're up to code, and the fees for those investigations can be passed through to tenants. Now, if you do think your rent was increased illegally at any point, please call LAHD and report it. And if, again, you ever want to look up like the specific rules about your rent increases, the section is The section is LAMC, sorry, LAMC 151.06. All right. So, second, I want to think about LARSO. The big part of it is the just cause protections. Now, what these are is that basically means that a landlord can only evict for a just cause. That is, a landlord has to have a reason for evicting. They can't just evict for no reason. They have to have a legally required reason for an eviction. And these are broken up into two different kinds. There's at-fault evictions, that is, evictions in which the tenant did something wrong. And the reason at-fault evictions usually include defaulting on rent, if a tenant breached the lease, or if they were using the property for an illegal purpose or criminal activity. Like if you were using your home to deal drugs in, that would be considered an at-fault reason for an eviction. Or if a tenant is causing damage or creating waste or doing serious harm to the property, or if they are refusing reasonable access, a landlord can go forward with an eviction. There are also no-fault evictions in which relocation assistance is required, and there are different notice periods for those. And no-fault evict or no-fault just causes include like if a landlord and or their family members want to move into the property, or if they want to demolish, substantially renovate, or remove the unit from the market, or if they're ordered by the government to evict. And again, if you want to look up all of these reasons, it's just LAMC section 151.09. Highly recommend looking it up. So there are some other tenant protection laws I'll go into quickly because, as I said, LARSO is kind of the premier one for us in Park La Brea, but there are a few others. Like at the state level, there's AB 1482, which is the Tenant Protection Act of 2019. And this is a Civil Code section 1946.2. The TPA includes just cause protections and rent control, and it covers most multifamily units in California. But again, because we have LARSO at Park La Brea, it's LARSO that applies. There is also the Los Angeles Just Cause Ordinance, and the Just Cause Ordinance, or JCO, includes only just cause protections. There's no rent control in it. So it just means that a landlord needs to have a just cause to evict, and it covers all residential tenancies in Los Angeles, unless, again, covered by the Los Angeles Rent Stabilization Ordinance. And then the last one is the LA Tenant Anti-Harassment Ordinance, or Tahoe. And this forbids landlords from harassing tenants. And uh, landlord harassment can include a whole host of things from abusing their right of access to threats to coercing them to leave to intentionally shutting off utilities. So if you are dealing with any kind of harassment, you could potentially bring a claim against the landlord for violating Tahoe. Um, and yeah, it's actually a very strong law. It just doesn't get enforced enough, unfortunately. All right, now I get to talk about uh, one of my favorite laws, the implied warranty of habitability. I actually really love this law because it's the whole reason I had a job for the last year and a half. What the implied warranty of habitability states is that landlords have to provide a unit that is fit for human habitation. And this is found in California Civil Code Section 1941. Basically, what that means is that if there is anything that impacts tenant health or safety, a landlord is obligated to fix it. And the best part about this implied warranty is that it is implied in every lease. It doesn't matter what the landlord or the tenant do, the landlord still has to fix things, and it cannot be waived in writing or by conduct. A landlord is always under an obligation to ensure that the place that they're renting out is safe and fit for human habitation. Now, the defective conditions can include a whole host of things, but the most common ones I've seen are infestations like cockroaches, bed bugs, rats sometimes, and also mold. Mold is a big one. I really recommend people take mold seriously if they're dealing with that, because mold can do a lot of damage if it's left untreated. And then also water leaks, lack of hot water, defective wiring, plumbing, heating, broken locks. These can all impact tenant health and safety, and a landlord is obligated to fix these things. Now, if a landlord, the only real exception to this is if a landlord can show that a tenant was actually causing these problems, then a landlord may be justified in a landlord would still have to fix them, but they may be justified in charging the tenant for those costs. But as long as you're keeping your place clean and not doing any damage yourself, well, landlord is obligated to fix them. Okay. So if you have a defective condition, if you're dealing with an infestation of any kind or anything like I just listed off, the first thing you always need to do is notify the landlord, preferably in writing. And then you have to give the landlord a reasonable time to fix the problem. And reasonable is the most lawyerly word around because it really does vary. Like if you're dealing with an emergency like a massive flood, reasonable would be immediately. But typically, reasonable is considered to be at most 30 days. So usually a landlord will have at least 30 days to fix the problem. And if you are dealing with this, document it as best you can, get photos and videos. And again, please notify the landlord. And don't just do it once, but repeatedly as long as the problem exists. Just keep complaining and do it in writing. Because unfortunately, I've had clients who say, "Oh, I was complaining about these problems for years, but I was only doing it like over the phone or in person." And unfortunately, that's a lot harder to prove in court if you ever end up having to sue a landlord for issues like this. So please do it in writing. It's much easier if you're leaving a paper trail. Now, if the landlord is not fixing the problem, tenants actually have some options. The first one is actually the one I typically recommend saving until later, which is withholding rent. You are legally obligated to, or excuse me, you're legally allowed to withhold rent if if the landlord is not fixing problems with the unit. I will say though, and this is just something to bear in mind, even if you're dealing with habitability concerns, if you withhold the rent, a landlord can still try to go forward with an eviction for not paying your rent. So I usually tend to recommend tenants save that until later, until they've exhausted other options, because nobody wants to have to deal with an eviction and going forward into court to deal with any of those issues. So because you do have some other options, the other one being repair and deduct, which is as a tenant, you can pay to fix the problem yourself as long as the cost of fixing it is less than 1 month's rent, and then you can deduct the cost of that repair from the rent. And it's an option that I also typically recommend just telling a landlord you're going to do before actually doing it. Because in my experience, as soon as a landlord hears that, oh, a tenant's going to try to fix a problem themselves, they will jump a little faster to maybe get it done. And then third thing you can do is complain to a government agency. I'll go more into which government agencies later in the presentation. But I do recommend doing this as well because this is also a good way to create a paper trail for complaints and creating evidence that the landlord was actually on notice of these problems. Fourth option, you can move out. This is called a constructive eviction. If a landlord is not fixing problems with the unit, then that's basically seen as a landlord not upholding their end of the lease, and you're under no obligation to stay. You can legally break the lease and move out, and if they do try to sue you for the remainder of the lease, then you can use constructive eviction as a defense. And excuse me. And the last option is a lawsuit. And this is what I was doing as a slum housing attorney. I was suing landlords for not fixing things for not fixing things in apartments and homes. Now, these lawsuits can be lucrative. You can definitely get some money out of them. However, they won't necessarily fix the problem either. I had clients who were dealing with habitability concerns for a long time, months to more than a year. And then even after we sued the landlord for not fixing things, the problems persisted. The landlord still wasn't fixing anything. I had a colleague who used to say no amount of litigation is going to turn a bad landlord into a good landlord. And unfortunately, that is true a lot of the time. Ashley, were there any questions that you think I should respond to? Okay. All
Nope, we're good.
right. Okay, I'm going to take a breath for a second. I realize I'm moving a little fast, so I can slow down, make sure everybody's getting everything. Um, all right, so the right of entry, this actually comes up a lot when landlords are, you know, I will say this usually comes up more when dealing with like individual mom and pop landlords who think the property they're renting out is kind of still theirs. But landlords do have a right to enter a tenant's unit. They do have a right to enter a tenant's unit, but only under certain circumstances, and there are requirements for it. So a landlord has to provide reasonable written notice before they can enter a tenant's unit, and it has to be for a good reason. It has to be during normal business hours. Now, reasonable is 24 hours minimum. So they have to give you some kind of written notice at least 24 hours in advance before they enter. And they can only enter for certain reasons. They can't just enter just because they want to. They have to be entering to make repairs or showing the unit to potential renters or buyers of the property. And if they don't provide, and those reasons have to be listed on the written notice as well. So if they don't provide that notice, uh, or if they don't provide a good reason, then you don't have to let them in technically. Now, but there is an exception to this, and it's if there is an emergency. If there's a fire or a flood, the landlord does not have to give you 24 hours notice. They can just enter your unit to make sure everything's safe and repaired. Now, the important part is a landlord cannot abuse their right of entry, but tenants can't completely deny access either. This is one of those things where, you do have to work with management on sometimes. Um, so a landlord can't just barge in at any time, but if they have a valid reason to enter, a tenant does have to allow them entry. So if at any point you have some issues, work with management. Do not change the locks of your unit without management's written approval. That would be considered uh, that would be considered something that they could potentially evict you for. So you want to make sure they have a right of entry at some point if they need it. Okay. So now I'll talk briefly about discrimination and reasonable accommodations. Um, this is more the civil rights aspect of housing because California has some very broad anti-discrimination laws because a landlord cannot discriminate based on certain protected classes. And those protected classes are listed here, and I'm going to wear myself out listing them all off, but I'm going to anyway. They cannot discriminate based on race, color, ancestry, national origin, citizenship, immigration status, primary language, religion, disability, mental or physical, sex and gender, sexual orientation, gender identity, gender expression, genetic information, marital status, familial status, source of income, which includes Section 8, military or veteran status, and age. Now, so they can't discriminate based on any of these, so they cannot refuse to rent to to anyone based on their any of these classifications, and they have to make sure that they are providing the same services to tenants who are part of these classifications. So there's also reasonable accommodations. So a landlord has to provide reasonable accommodations to tenants with disabilities. But there has to be a nexus between the disability and the accommodation. So if you need an accommodation, it needs to be something related to the ways in which you are disabled. So, if you have a physical disability and you need to, and like you, or if you're on, excuse me, sorry, I think the example I usually use, like if you're on Social Security or Social Security disability, and your check comes on the third, but rent is due on the first, you can ask for a reasonable accommodation that the rent come due on the fourth instead. Like that's a reasonable accommodation that a landlord has to make to a tenant. But these accommodations cannot put an undue burden on the landlord. So it can't cost too much or create too much of an administrative burden on the landlord. It has to be something that they can reasonably accommodate. All right, evictions. Now, this is what I was doing for several years. I was doing eviction defense. I was defending tenants against them, and there are technically two types of evictions. There are unlawful detainers and forcible detainers. Now, forcible detainers are typically reserved for squatters or people who were never legal tenants in the first place. So I'm going to, I'm not going to talk about those. This is exclusively dealing with unlawful detainers, which is when a landlord is trying to evict someone who was a lawful tenant at some point. So all evictions start with a notice to quit, and it can be for certain periods, 3 days, 30 days, 60 days, or 90 days, depending on what the eviction is for, what the just cause of it is. 3-day notices to quit are usually referred are usually for at fault just cause evictions. 30, 60, and 90 are typically for uh, no fault just cause. And 90 days, I think, is typically reserved almost exclusively for evictions dealing with foreclosure. Now, these notices, they have to be in writing, physical writing. They have to be proper. They have to have all of the required language in them, and they have to be properly served. If a landlord does not properly serve a notice, or if the notice is defective in some way, then that is enough basis to win in an unlawful detainer. So you got to make sure if you do ever do get a notice to quit of any kind, I would recommend seeking some kind of legal counsel to ensure that the notice is proper, that it was properly served, and what your defense is or how you should handle it might be, because there are all kinds of reasons for one. Now, after the notice to quit expires and a tenant has remained in the property or has not complied with the notice, then the landlord can file the unlawful detainer complaint with the court. They get the unlawful detainer complaint along with a summons from the court. They have to try to personally serve the tenant with that summons and complaint. Or if they can't personally serve the tenant, they can serve it by posting, which means they tape a copy of the summons and complaint to your door and mail you a copy. Once a tenant is served with the summons and complaint, they have 10 business days to file an answer, which is a specific form. It's UD 105, and 10 business days is typically 2 weeks. It used to be 5 business days, and it was only recently, just in the last couple of years, extended to 10 because so many people were defaulting. And it is absolutely essential if you ever do get served with a summons and complaint, you really do need to make sure you file an answer within those 10 business days, because if you don't, then you can get a default judgment entered against you. And what that means is that the landlord can go forward with a lockout without you ever getting your day in court, basically. And if you do get a default judgment entered against you, there are ways of getting it set aside so that you can get a trial or can defend yourself. But getting a default judgment set aside is tricky and difficult. So if you can avoid it, you should really make sure you're filing an answer before that happens. Now, if you do file an answer, good, you have preserved your affirmative defenses, then the case would go to trial. Now, uh, if you go to trial and you win, congratulations, you get to stay and you get to keep paying rent. And unfortunately, in these cases, uh, during the eviction period, while the eviction is ongoing, the landlord is not supposed to be accepting rent, but the rent keeps accruing anyway. So usually, even when a tenant wins in an eviction, they have to end up handing the landlord a check anyway for all the rent that came due while the eviction was happening. Uh, and then if you go to trial and lose, then, and I tell tenants all the time, this is the worst case scenario, because then not only do you get a judgment entered against you, which shows up on your record and makes it more difficult to find a new place, but then the sheriffs will eventually show up and lock you out of the property. And how long between the judgment and the sheriff showing up really varies. Basically on how fast the landlord moves and how busy the sheriffs are. But it could be anywhere between like 2 weeks to a month or a month and a half. And you do have to move out. The sheriffs will show up and kick you out. Now, you don't have to go to trial. You don't have to fight to stay. You can always settle. And I would say 90% of the cases you typically do end up settling because, as I mentioned, trial is risky. You never know which way a judge or jury is going to rule. Um, so a lot of folks are fine with settling, and you can always negotiate. You can reach a settlement right up until there's a judgment in trial. Um, and I will say, in my experience, for unlawful detainers, what a good settlement is really does depend on your situation, and what you think is good for you, and um, what works for you, and depending on the strengths of the case. That's not something I can determine without knowing the case specifics. But uh, I will say though, if you do settle, if you agree to move out, you have to be aware that the move out date that you agreed to is a hard deadline. You want to make sure that if you do agree to move out, you are giving yourself enough time to find a new place. Otherwise, the landlord could potentially go forward with a lockout the day after your agreed upon vacate date. So that's just something to bear in mind because unfortunately, I have had situations where a tenant agreed to move out and then couldn't find a new place in time and ended up getting locked out by the sheriffs with nowhere to go. So that's just something you really want to be aware of if you ever are negotiating a move out agreement with a landlord. So there are affirmative defenses to eviction. There are actually a lot of them, but these ones I've listed here are the most common and maybe the strongest. The first one being waiver or estoppel. These two are similar, not exactly the same, but they differ in a way that only lawyers would really understand. Um, but basically, if a landlord has accepted rent after a notice expired, that's considered a waiver of that notice. Or if they, through word or action, made it seem like the tenant wasn't going to get evicted or made it seem like everything was fine, that would be considered, you would have the defense of estoppel. That is, you relied on their words or their actions, and you reasonably didn't think it would be a problem. There's also retaliation. A landlord cannot retaliate against a tenant for exercising their rights in any way, for complaining about habitability issues, for forming a union. These are things a landlord cannot retaliate for. Now, if a landlord tries to evict a tenant within 180 days of a tenant doing any of these things, then it creates a rebuttable presumption that the landlord is retaliating against that tenant. Now, that is just a presumption, and it's a presumption the landlord can overcome if they can prove that there is actually a valid reason for the eviction, but it is an affirmative defense if the landlord is clearly retaliating. And then the third one I mentioned is improper notice. As I said, if the notice is improper in any way, if it doesn't have the right words or if it's served incorrectly, then you can win on an eviction just by pointing out the flaws in the notice. And this was always kind of my favorite because I always loved it when like eviction attorneys screwed up and we could just get the case dismissed without even really trying because the notice was incorrect. We got a lot of cases dismissed at one point because the city changed the notice requirements and not enough eviction attorneys caught that change. So we were able to get a bunch of these cases taken care of without even really doing much work, but they catch on pretty quick. I will say the eviction attorneys do typically know what they're doing. So this isn't necessarily a defense you can rely on. There's also, but if it's also a defense if you complied with the notice. So if you get, say, a 3-day notice to pay or quit, and you pay all of the rent demanded within the 3 days before the notice expired, then you have complied with the notice, and they can't go forward with an eviction based on that notice. Or if they're doing a breach, or if they're evicting you for a breach of the lease, and they gave you 3 days to fix the problem and you fix the problem, then you can argue in court, well, you complied with the notice, they can't evict you anymore. And then there is the breach of implied warranty of habitability. Breaching the warranty is an affirmative defense to eviction, particularly for not paying your rent. As I mentioned, you do have a legal privilege or a legal right to withhold your rent if the landlord is not making any repairs to the property. So if they try to evict you for not paying your rent, then you can go in front of the court and say, well, here are all the problems with my unit, my apartment, and here are all the times I complained, and here are all the ways in which the landlord did not fix the problem. Then the landlord or the court would typically say, yeah, okay, oh, excuse me. Then the court would typically say, okay, yeah, they breached the implied warranty. They don't have a right to evict you for non-payment. And then also, discrimination and harassment are also affirmative defenses to eviction. I will say these can be difficult to prove. It is if a landlord is caught discriminating or harassing tenants, that could be a defense to eviction. But I will say landlords are typically good at like finding valid reasons that seem okay on its face. So, but unless you have like pretty rock solid evidence that there is discrimination or outright harassment happening, these defenses can be a little hard to do, but they are options. Great. So here are some general tips I give to basically every tenant I talk to. The first one is get it in writing. Uh, nothing the landlord says over the phone or in person counts. Everything should be in writing. You want to document any issues with your unit and any communications with management. You really do not want to be in court and, have your only evidence being, well, she said this or he said that. You want to make sure everything is documented in writing. And especially if there are any rent payments, you want to make sure there is a written record of those as well. I can't tell you how many times I've had clients who were like, well, I paid all my rent, but I paid it in cash and I never got receipts. That's definitely not a situation you want to find yourself in. Now, this is Park La Brea, so they don't roll like that, but if you ever in the future, if you ever are dealing with a landlord like that, you should be wary of it. Uh, Another second thing, talk to your neighbors. As I said, if you're dealing with an issue, then your neighbors probably are too, and you are much stronger together. We are all stronger together. We're all in the same buildings and dealing with the same landlords. So, it's always good to talk to each other and make sure you're working together to try to get issues resolved. Third thing is do not self-evict. I've had clients who will get notices to quit of some sort, or they're told by the landlord, "Oh, we need you to move," and then they'll just move out. Don't do that. Consider your options. You can always negotiate. You know, don't Tenants often don't know their rights and they get nervous about this, but just keep in mind you can always negotiate if you need time to move. And fourth, this is very relevant, but know your rights. I can't tell you how many times I've dealt with landlords who really counted on tenants just not knowing what their rights were. It's a little knowledge goes a long way, and nothing freaks landlords out more than tenants citing like the municipal code at them. So just make sure that you know what you're talking about in your communications. And this is why I was pointing out like legal citations to certain laws, because if you can cite those laws and those rules at landlords you feel like they're getting violated, that really does count for a lot, and it shows that you know what you're talking about and you know the rules. And then the last thing I'll tell you is read your lease. This one kind of gets lost a lot, but the lease is typically, it's the rules of your tenancy. So it is the go-to. It's the thing you should refer to if you ever have a question about like what your rights are with regards to the tenancy specifically, and what you need to do in certain circumstances, because those things are complicated and they're long, and but they should address basically every eventuality for the most part. And if you have any questions about that, I am always happy to answer them. So then there are government agencies. There are a few that I typically refer folks to. The first one is the Los Angeles Housing Department, LAHD. And LAHD typically handles things like illegal rent increases, reduction in services, habitability, illegal evictions, harassment. I highly recommend complaining to them if you are dealing with issues with management, because as I said, LAHD covers all LARSO properties, which Park La Brea is one. Um, I will just give you a heads up though, LAHD can be a little toothless. They may write a strongly worded letter, but they might not do much more than that. Now, I recommend complaining to them anyway, just because, as I said, those complaints can be a very useful and valuable written record if you do ever find yourself in court. But yeah, just, don't necessarily expect them to solve the problems for you. Um, and then the second one is the Los Angeles County Department of Public Health, or LADPH. This group is a county-wide department, and they handle exclusively issues with habitability, so mold infestations, things like that. You kind of have to stay on them about things. Like if you complain to them, they'll send the landlord a courtesy notice to abate, but they won't do an actual investigation unless you follow up with them and the problem isn't fixed. Um, and then the last one is the California Civil Rights Department, which handles exclusively discrimination issues. So if you think you are dealing with discrimination, they are the one to complain to, and they will do an investigation. They are, I think, probably the most thorough department I've ever dealt with. They take their job pretty seriously. So here are some further resources I recommend to everybody. The first one is Stay Housed LA. I love this program a lot, not just because I used to work for them, or when I was an eviction defense attorney, I was hired through the Stay Housed LA program. It is a great program. They have a lot of great workshops online, and a lot of great information about what your rights are. And they also provide legal representation to tenants facing evictions if you qualify for their services. And but because they're kind of underfunded, they can't cover every tenant, or they can't cover every part of the city or every part of the county, but they do a lot of good work, and there is a lot of good information on their website. So I really do recommend checking them out. And then there are the legal aid firms. There are a lot of them in LA County. There's Neighborhood Legal Services of LA County, which is the one I worked for when I was doing eviction defense. There's Betsedic, Inner City Law Center, the Legal Aid Foundation of LA, the Eviction Defense Network, and BASTA. All of these all of these legal aid firms handle housing in some way or another. Pretty much I believe all of them handle eviction defense. Some of them also do like slum housing work, and they are worth reaching out to if you need help or you need an attorney. And then there are also the LA County self-help centers, which are at every court. There is a self-help center, and they often help with like file. They can help you with like filing an answer, or if you have any questions about the process, they may be able to give you some more information. And then if you do need a private attorney, you can refer to the LA County Bar Association. They have a private attorney referral service if you need a housing attorney somewhere in the county to help you. They're a good service, or they're a good group to check out. Okay, so that was it. 45 minutes on the nose.
Love it.
So,
It's like you practiced. Thank
uh,
you so much, Henry. We do have a few questions in the chat, and I'm just going to go like the earliest one, like the first received and onward. So we might be jumping around a little bit. But the first one is from Reiko, and it's in the chat, but I'm going to read it out loud for us. So, ever since the management changed, we have not received any updates from PLB regarding reimbursement for the charges related to an extra garage space that is not theirs. Like they don't have one. Who should they contact to resolve this? They've tried emailing Liv multiple times and don't get those responses. For that one, would you recommend Sylvie?
yeah, I think so. So there are, and I would recommend checking out PLBRA's website too, because we list like all of the relevant folks and their contact information on the website. Um, yeah, even for me, it's hard to keep track of who is responsible for what around here. But yeah, I just make sure you're communicating with them in writing, and you can always go to the leasing office and just annoy them until they actually try to help you out. But yeah, I would, I think Sylvie would be one to reach out to. And unfortunately, I will say management is just not great around here. It's an unfortunate fact of living here. There's a lot going for us here. Responsive management is not one of them. But I would just say just be persistent and you should be able to get a response from them eventually.
Yep. Consistency is going to be key here. And I see in the chat that you have reached out to Sylvie and also forwarding those issues to Mario. I've also met with Mario on a number of different resident issues. Um, Feel free if you ever want to go into the office together. It's in a random apartment tower right now, a tower apartment right now. Happy to kind of just go in with you and um, just kind of keep the pressure, for lack of better wording, on them to make sure that you aren't getting overcharged and yeah, your issues are being uh, followed up on. And then the second one, the gym membership fee was raised without any notice. Is that legal?
Yeah, so the gym is not technically a part of Park La Brea. They are a third party. Um, so yes, unfortunately, there really no rules, or at least you don't have a right to the gym, I guess. It's not an included amenity, so the gym can do whatever they want. And PLBRA has repeatedly tried to get them to introduce some kind of discount or something, and they are just really stubborn on this. They're really not moving on that. But unfortunately, yeah, they can do whatever they want, essentially. It's the only thing we can do is really vote with our wallets and either give them our membership or not. I don't. I used to be a member, but then yeah, they raised the rates and I was like, I'm out. Um,
I mean, if we want to start like striking or doing some sort of very vocal in numbers way to get their rate decreased or some kind of support for us, that would be something to think about.
mhm,
But you're right, it's not part of management, it's its own third party company.
mhm.
Mm. The next one, I am going to butcher what this this acid is called. PLB
Glyphosate,
Brightfield
glyphosate,
glyphosate
glyphosate. Um,
in the garden area, which completely burned a large section of grass. Um, and it sounds like here Reiko has kind of already contacted the city and has had an official inspection report. So what can she do here? What can they do here?
so this would be something you need to talk. So, is it illegal to apply without providing proper notice or posting signage? That's not my area of expertise. That might be something to talk to poison control about, honestly. That's kind of outside of general tenants' rights. I will say though, if they're responsible for that and they did something and you got sick because of it, then you're just dealing with like personal injury and that's something you could potentially sue them for. I that's a little outside of my expertise. That might be something you want to call poison control about and kind of see what rules they have about that. But generally, yeah, if management or their agents do something that causes a tenant harm, then that would be considered negligence, and that's something you could bring a claim for against them.
Right, thank you. And just thanks for the transparency of what you do have experience and background with, and then things that don't. I just think that's very trustworthy and just like humbling. I love that. Thank you. So the next one was from, I believe I got all of Rico's. Um, the next one is from JT. They've reported mold in October 2025, and they haven't fixed the leak that is causing it. Um, They heard you earlier in the presentation about not paying the rent, but is scared of eviction for that, right? And then also, if they sue, would they be able to get back that money or the pay on that rent from the first? And so, it sounds like they've had an inspector come from the county already, and they said they don't deal with mold, but they can tell the landlord to fix the cause. How do
Mhm.
we escalate this and make sure that this is something that can be done quickly, especially since it's been October 2025?
Yeah. So, well, you are talking to a government agency about it. That's usually how I would recommend uh, escalating the issue. Now, the way lawsuits for breach of the implied warranty habitability work is first, you have to prove that there was a problem. You have to prove that the landlord had notice of the problem. Um, and you have to prove that even after a reasonable period of time, they did not fix the problem. And if all of those are cleared, you could potentially bring a claim against them. Now, the way the way breach of the implied warranty of habitability works is that you're not entitled to all of the rent back. You're entitled to a portion of the rent back. So the landlord it's called an abatement. Basically, a court would say, "Oh, okay, the property was this percentage less habitable, so you're owed this percentage of the rent back." Um, so, but it doesn't start from the first time necessarily you mention the problem. It's from when basically it's after the reasonable period of time passed that the landlord didn't fix the problem. Um, so I mean, it sounds like you are doing what you should be doing, and I would just make sure you are documenting everything, make sure you got photos, videos, and you are communicating in writing. If it's still a problem, basically just keep complaining and writing to the landlord too. Keep emailing them and just saying like this, hey, this is still a problem. It's now been 90 days and this still hasn't been fixed. Um, and just keep documenting it. And you could potentially bring a claim in small claims court, which has a limit of $12,500. I don't know how much money you'd be able to get out of it. I will say too, failure to fix problems is also considered tenant harassment under Tahoe. And Tahoe allows for 3 times any compensatory damages. So like if they say like, oh, you're owed a rent abatement of $500, then that could be $1,500 that you're actually owed under Tahoe. But don't quote me on that. It's just, that's something you can uh, do if you ever want to try to sue them for any back pay or any back rent that you may be owed.
Great. Awesome. The next one is from Beth. Beth stated, have been having a lot of problems with Built and no response from management. Have had messages and help though from the NYC office of Built. What are other people's experiences so far with Built?
Uh, I mean, uh, I, I hear a lot of complaints about them. I don't, they just seem kind of not really on the ball. They seem to be just like another blood-sucking middleman of a tech company that is just like trying to just, yeah. I don't dealing with that's the thing. A lot of management can do a lot of things without it technically being illegal. Them just being bad at their jobs is unfortunately not against the law for the most part. At some point, because at some point it's just frustration. It's not actually doing any harm. But if it does start to do like actual serious harm physically or mentally, then it could potentially be negligence. But Built is just like, it's just a frustrating service to deal with. Um, and again, management is, not known for their competence. And as I said, I had a colleague who said, no amount of litigation can turn a bad landlord into a good landlord. And it's just a fact of the matter that, landlords, they can get away with a lot, just because they know they don't have to really be on the ball because they know tenants don't have any other options. Um, but it is, I don't know if there's really much that can be done about Built specifically. Um, they're just, they're an agent of management essentially, and they're a third party vendor. Um, and they can be just obnoxious and frustrating to work with. But, most of the time it's just they just collect the rent.
Yep, agreed. And recently I was helping a resident who had an issue because they paid via check. And with a long story short, the check was lost in the mail. We tried paying via Bilt. That's locked. So as like a heads up, when you're late on rent, they just end up locking Bilt anyways. And I'm like, don't you want your money to pay your rent? Um, and when we tried going in person to um, the office and try and help this resident, they just kept saying it's core, it's a group, it's the core team who is in charge of basically all the finances, and there is no one on site. It's all an off party or off site um, party, essentially like a centralized team somewhere else. And so it's so unfortunate. I think I saw that comment there from Beth as well. PLB just seems just so completely uninvolved, especially with something as important as how we are paying our rent and how those are um, just getting transactioned correctly for our residents. And so it's so unfortunate. Um, but thank you, Henry, for answering that. Just really quickly as well to Reiko, just in case you didn't see my response back to you, if you need help finding your complete ledger, I can help you get that. You do not have to wait for Mario to send that. I believe we can get that online as well. So I'll find you. I know you're on the Facebook group, so we can connect shortly, or you can send me an email. My email's in the chat as well, and I can help you find a way to get the PDF of like literally the entire time. Um, Great. And then thank you, Henry, for putting Tahoe, which is an acronym. It is the Tenant Anti-Harassment Ordinance. And then I just want to make sure I'm not missing anything.
Barbara's asking what happened to the PLBR efforts to get PLB to restore the payment box on site. They we failed.
We,
We
yeah,
tried.
we tried our best. We met with management multiple times. We, for lack of better wording, tried twisting the arm as much as we can do. We unfortunately are not management ourselves. And so we really did try. We had so many meetings, and we can't force them to do anything, right? We can just keep advocating. Like I said in the chat, I just copy me on any emails because nothing I love more is sending forwarded emails and pestering and making sure I get responses. And so I guess Henry said the kind of the right thing of we failed, but at the same time, like we really did everything we could outside of not being management ourselves and just keeping it there as an option for the community that uses it.
I, you know, I it's frustrating though because I mean Park La Brea, their management's just cutting corners in any way they can, and unfortunately they're not breaking the law. They're legally legally they have to offer tenants a non-electronic alternative to paying the rent, but they're just saying like, oh, well, you can always mail the check to us. That's your alternative. We don't have to collect it and process it on site. I don't know how that's saving them any money. I feel like it can't be somehow, but legally that's not breaking the law to remove that box.
Yep. Yes. And definitely good luck with mailing. As a heads up, um, there is, to my understanding, that core team that I was mentioning earlier, one individual has the keys to come and collect from the mailbox. And so it's it is also a little bit dependent on having a staff member check that mailbox frequently. And so if it arrives like early or late, like it's hopefully they're checking it quite frequently. I am not sure, so I cannot say how often, but I do know it is like one individual from the core team that has the keys and just does like general checks. So it's so tough when mailing it and making sure that your check is in on time. Um,
Um,
so yes, and a lot of conversation happening in the chat. I know we are a little bit over time. I would love to keep the conversation going. Feel free to join us at our next PLBRA meeting where we can always have more of this discussion. I just want to drop into the chat as well the way to get the ledgers when you go to Park La Brea. I'm going to try and type this very quickly. Park La Brea Apartments, apts.loftliving.com. You can go under payments, payment history, and there you can see all your charges and your payments. I can send out a message to you, Reiko, or put it onto our PLBRA.org website as well, in case anyone else wants to see that. But again, thank you so much to Henry. You just shared so many great resources and information, and just we answered the residents' questions, so lovingly and just with such care and insightfulness. We can't do it all, but I think as long as we are trying and we have the care and when we keep pushing back, it's what we can do, right? And so thank you, Henry, for always leading that charge.
and yeah, thank you all for coming. As I mentioned, it's really important that we all know our rights and we all work together on this. And I really would encourage you all to join because we are stronger. The more there are of us, the stronger we are. It's easy for management to ignore one tenant. It's harder for them to ignore 100 or 1,000. So please join. It really matters a lot. Really helps us maintain, you know, manage or try to hold management accountable. And it's only $20 to join. So, I think and we do movie nights. I run the movie committee too. So,
Yeah, exactly. I was going to say power in numbers and your membership dues of that $20 a year. We try and put it back to you all, whether it's in some snacks at movie nights or other events coming up. So we try and always bring that back out to you all in some kind of way, right? So thank you all so much. Have a lovely night. Hope to see you all at the next PLBRA event. Thanks. Have a good night, everyone.
Thank you all.